Within this module, we will explore some aspects of employment law as they apply to the paramedic provider. At the onset, please keep in mind that there are numerous laws at both the state and federal level that govern the employment relationship between EMS agencies and their employees, and this particular module explores only the proverbial surface of these laws, exploring some of the most prevalent or common laws while not delving into others. If you find yourself in a position where you are responsible for compliance with these or any other employment-related laws, considerable additional education is required and should be pursued. With that in mind, once you have completed this module, you should be able to discuss the impact of selected employment laws on EMS agencies and providers. This module addresses some federal employment laws related to EMS. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other legal provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. There are numerous laws at the federal level that have a significant impact on the employment relationship between EMS agencies and their providers. In no particular order, we will begin with the Americans with Disabilities Act of 1990, which was subsequently updated in 2008 by the ADA Amendments Act. In brief, the ADA prohibits discrimination against disabled individuals with the intent to provide disabled individuals with the same employment opportunities enjoyed by non-disabled persons. So long as a person with a disability can perform essential functions of a job either with or without reasonable accommodations, he or she cannot be excluded from employment opportunities available to other non-disabled individuals. The keys for compliance with this law by EMS agencies include defining essential job functions for employees while also having an idea of what type of accommodations are reasonable versus unreasonable given a specific disability. Essential job functions are fundamental things that an employee must be able to physically do as a required part of the job. It is up to the employer to determine just what these essential job functions are within the workplace. Lifting patients, being able to start an IV, performing CPR, safely driving an ambulance, the ability to hear and communicate verbally, and other various tasks or duties are common essential job functions for a paramedic. If a disabled person needs an accommodation to perform an essential job function, and that accommodation is a reasonable one, the employer must provide that accommodation. Reasonable accommodations may include changes to existing facilities to make them accessible, job restructuring, modified work schedules, modification to equipment or devices, and so on. For an employer to find an accommodation to be unreasonable, it must be able to show that the proposed accommodation would create an undue hardship for the employer, which means the accommodation would require significant expense or severe difficulty to provide. Again, so long as a disabled person can perform the essential functions of a job either with or without reasonable accommodations, he or she cannot be excluded from that employment opportunity on the basis of his or her disability. The next major piece of federal legislation we will explore is the Civil Rights Act of 1964. This law consists of several titles or sections, with the most pertinent title being Title VII, which covers equal employment opportunity. Simply stated, Title VII prohibits employment discrimination based upon race, color, religion, sex, gender, or national origin. Prohibited discriminatory actions include not only those related to hiring of employees, but also compensation, assignments, transfers, promotions, layoffs, recalls, recruitment, testing, fringe benefits, pay, retirement plans, disability leave, and other terms or conditions of employment. Harassment or retaliation are also considered to be discriminatory practices which give rise to Title VII violations given sexual harassment, non-sexual harassment, or the existence of a hostile work environment. Title VII has also been amended several times since its passage in 1964 by other laws, such as the Pregnancy Discrimination Act of 1978, which prohibits gender discrimination on the basis of pregnancy, the Civil Rights Act of 1991, which codified the disparate impact theory of discrimination while also expanding the types of damages that could be recovered by a successful plaintiff, and the Lilly Ledbetter Fair Pay Act of 2009, which amended the 180-day statute of limitations for filing a complaint by recognizing each individual paycheck impacted by such a discriminatory action as a new occurrence of discrimination that resets that 180-day clock. In 1967, Congress also passed the Age Discrimination in Employment Act, which made it illegal for employers to discriminate against individuals in any aspect of employment just because he or she is 40 years of age or older. The Family Medical Leave Act was passed in 1993 to balance the demands of the workplace with the needs of families, to promote the stability and economic security of families, and to promote the national interest in preserving family integrity. To summarize the law, eligible employees under the FMLA may take up to 12 work weeks of protected leave within a 12-month period for certain medical-related conditions or occurrences, such as the birth of a child, or to address a serious health condition that makes it impossible for the employee to perform the essential functions of his or her job. The law extends the time frame of the leave to 26 work weeks if the leave is taken to address the care of a covered military service member with serious illness or injury. While on FMLA leave, the employee's job is protected, meaning the employee must be returned to his or her job or an equivalent position upon the completion of the leave. There is no requirement that the leave be paid, although many employers allow the use of accrued vacation or sick time while on FMLA. Many states, Wisconsin included, also have their own versions of family medical leave laws, which may provide additional benefits to employees. The Fair Labor Standards Act of 1938 governs some very important employment benefits such as minimum wage, compensable hours, and overtime requirements. It is also the FLSA that governs child labor within the United States by establishing minimum ages to work, maximum hours a child may work, the minimum pay rate for working children, and prohibitions against children performing hazardous functions or work. Some key provisions for EMS agencies govern hours that are to be paid, which often includes waiting time, on-call time, sleep time, and meals, depending upon the details. Overtime must be paid at 1.5 times the employee's hourly rate once he or she exceeds 40 hours worked within a week. If an EMS provider works 24-hour shifts, overtime must still be paid for hours worked over 40 hours per week unless the employee falls under what is known as the 7K firefighter's exemption. While this is an oversimplification of the law's provisions, if the EMS provider performs firefighting duties for the employer, overtime need not be paid until the employee works more than 212 hours within a 28-day period, or a prorated total if calculated over anywhere from 7 to 28 days. Stated another way, if the EMS provider is also a firefighter, overtime is typically not available under the FLSA until that person works more than 53 hours in a typical week. Similar to other laws discussed here, the FLSA has been updated over time by other laws, one of which is the Equal Pay Act of 1963, which prohibits discrimination on the basis of gender in the payment of wages or benefits. Another law that updated the FLSA was the Patient Protection and Affordable Care Act of 2010, which provides reasonable break time for employees who are recent mothers to express breast milk for her nursing child as needed for up to 1 year after the child's birth. The employer must also provide a place other than a bathroom that is shielded from view and free from intrusion from coworkers and the public, which may be used by an employee to express breast milk. In 2008, the Genetic Information Non-Discrimination Act was passed to prohibit discrimination against applicants, employees, and former employees on the basis of their genetic information. Another huge law that impacts workplaces across the country, EMS agencies included, was the Occupational Safety and Health Act of 1970. This law established the Occupational Safety and Health Administration and subsequent regulations governing workplace safety and health requirements. Failing to maintain a safe workplace can result in significant fines, and the law even recognizes that industry-wide standards for safety and health may serve as the basis for enforcement action under the OSHA General Duty Clause. We covered workforce safety and wellness in several other modules, so we will not delve any further into these various employee safety and health requirements. Given potential exposures to bloodborne pathogens, the Ryan White Comprehensive AIDS Resources Emergency Act of 1990 was important to EMS and other healthcare workers in that it allowed for emergency response employees to be properly and promptly informed when they may have been exposed to potentially life-threatening infectious diseases as a result of their contact with patients. Lastly, there is also a law that protects service members' reemployment rights when they return from a period of service in the uniformed services, including those called up from the Reserves or National Guard. That particular law is the Uniformed Services Employment and Reemployment Rights Act of 1994. This law protects not only the employee's job rights if deployed, but also certain benefits, such as health insurance and pension plans. Now remember that this list of federal laws governing the employment relationship is by no means exhaustive. Many states have similar laws that provide additional protections over and above those provided by these federal laws. It is not uncommon, for instance, for a state law to extend non-discrimination protections to other categories or classifications of people, such as marital status, sexual preference, criminal history, or those who use lawful products. Another important caveat with these laws is that some of them do not apply to smaller employers, or the application of the laws can vary depending on whether the employer is a governmental entity versus a private party or entity. Ultimately, think of this particular module as the equivalent of an awareness-level presentation to just make you aware of the existence of these various laws. We hardly scratched the proverbial surface of these various laws and their numerous provisions. If you are involved in EMS agency management, union leadership, or simply just want to learn more about these various laws and how they impact the EMS employment relationship, WCTC does have courses that address the legal aspects of providing emergency services, and you are encouraged to enroll in that or other courses that deal specifically with laws that impact emergency service agencies. You may also want to conduct your own research on these various laws as well. Given your completion of this module, you should now be able to discuss the impact of various employment laws on EMS. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an Attribution Non-Commercial Share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.